main ways of settling disputes. The first way is to go for litigation. The judicial system is part of any country all around the world. It's part of the sovereignty of that country or this country or that country. So the litigation is the first way of settling the dispute. And then we have what we call the ADR, the alternative dispute resolutions, which is different tools, different services, different ways. And we have a lot of things we can mention: arbitration, mediation, conciliation, negotiation, adjudication. So we have different tools in this industry to settle our disputes. But all of these ADR tools, services, call it whatever you want, products, call it whatever you want, because I think in Islamic finance we are more familiar with products. So call it products if you want. It's mainly two main baskets. I can put it in two main baskets. The first basket, the arbitration, and like adjudication and etc., which is, by the end of the day, you can say it's a private litigation. It's a private court. By the end of the day, you have neutral. He or she will decide who has the right, this or that. So even if you are happy, if you are not happy, if both parties are happy or not happy, by the end of the day, there is an award. So this is the first basket. The second basket, which is mediation, conciliation, negotiation, all of these services, products, is based on the parties' choice. So that means they will not be forced to reach a settlement. They can, by the end of the day, after the settlement hearings, they can reach no settlement at all. So it's purely and completely based on the parties' choice. They will not be forced to do A or B or C. So this is ADR again, which there is a lot of tools, services, but it's mainly two baskets, and you will see that more in the coming slides. So what is ADR? This is what is ADR and why. So the first, you can say, service or tool is arbitration. And as I mentioned, it's an agreement between two or more parties to refer their dispute to arbitration, all or part of their specified dispute, which occur or may occur out of their legal relationships. And also, before I go more, why we choose, or why usually in commercial contracts, including banking and finance and insurance, why the companies, the parties, they prefer ADR over litigation for different reasons. First of all, I'm talking about ADR generally, and then, for example, mediation, conciliation has more benefits or more, you can say, benefits for the users. I will mention that, but now, generally speaking, all the ADR services or products, why the parties they choose that for different reasons. First of all, I can say the flexibility of the parties. The flexibility could be illustrated in choosing any applicable law. For example, in international contracts, for example, we have different companies, different parties from different countries. So some of these parties, they are not familiar with, for example, the laws and regulations of the other country. So the ADR, generally speaking, will give the parties autonomy about choosing any applicable law, any language, any venue, any place, any time, any arbitrators, without any restriction in terms of gender, in terms of specialty, in terms, etc., etc. So I can say in one word, flexibility. Number two is the confidentiality. I think also this is really, really important for the private sector, for the companies, for the commercial, sector, because as we know, the company's reputation is really, really important for it, and it's worth a lot of money. So the parties usually, they are protecting or trying to protect their reputation by choosing ADR tools, arbitration, mediation, because if you are gonna settle your dispute through ADR, the journey of settling the dispute, it will be private, confidential. No one is allowed to leak any information related to the dispute, and this means a lot for the parties. Another aspect, and the third benefit is it's fast fast dispute resolution. Usually, because if you have a specialized arbitrator or mediator, you will have someone more efficient in settling your dispute, in addition to the things that I'm going to mention in the coming slides. So again, the second way of settling dispute, as I mentioned, mediation is a confidential, interest-based negotiations facilitated by neutral third party trained to assist the parties in communicating and resolving their disputes. So if you are comparing arbitration and mediation, a mediation is more flexible, mediation is usually faster, mediation is protecting the confidentiality more than the arbitration, because maybe some of you will ask, both of it's confidential, but by the end of the day, in the majority of the countries all around the world, you can set aside or challenge the award in the court. So you might, the award might be disposed in the court to more parties or more people, but usually in mediation, after the parties, they reach a settlement, because it's pure parties, decision to reach a settlement. So no need to go to any other place to challenge the award, or like in arbitration. So because of that, mediation is more confidential, more flexible, more faster. And maybe some of you, for me, the first time I heard about mediation, I thought it's not that efficient, because no one will force the party to reach a settlement. So I thought the possibility of reaching settlement through mediation, conciliation is 10%, 15%. But what I found in the world, and also in our experience in SCCA, usually if the mediation managed in the right way, based on sophisticated rules, managed by a sophisticated and trained mediator, and also in the right place, usually the settlement ratio reach more than 60%, sometimes 70%, so which is very efficient. Sorry. So, brother and sister, let me very quickly compare between litigation and ADR, generally speaking, arbitration and mediation, confidentiality. And I mentioned there is huge difference between arbitration, ADR, and litigation from this point of view. Number two, about the fast and flexible procedure. As I mentioned, usually the litigation, it takes more time. The cases in the court take more time, and the flexibility, for sure, it's less. A lot of judicial system will not give you that flexibility about choosing the time, choosing the venue, choosing the judge. But here in arbitration and mediation, you can choose all of these things. Also, the finality of the award or judgments. For sure, as you know, in all the judicial system all around the world, you can go through 3 or 4 steps in to have a final judgment. But in arbitration, the majority of the world, the arbitral award, for example, is final, is not appealable, and this means a lot of time and efforts. And finally, the enforcement of the judgments comparing to the arbitral awards. As you know, to enforce the court judgments, if you'd like to enforce that outside the country the judgment has been issued in, you need sometimes like treaties between countries, and that is not common or is not wide globally. But to enforce arbitral award, it's enough for a country to be part of the New York Convention to recognize and enforce the foreign arbitral awards. Now we have 161 countries all around the world is a parties or signatories to New York Convention, including Malaysia, all the GCC countries, Saudi, Emirates, all the countries. You can say the majority, the vast majority of the countries where is the Islamic finance in, all of these countries are signatories to a New York Convention. What does that mean? As soon as you have an arbitral award issued in any country of these 161 countries, it will be enforced in any other countries without having these bilateral treaties between, for example, if I have a dispute between a party in Malaysia and the other party in Egypt, you don't need to have these double treaties between Malaysia and Egypt. But if there is an arbitral award has been issued, for example, in the parties from Malaysia and Egypt and the assets in Argentina, so even if the assets in different countries, you can enforce the award in any countries, parties or signatories to the New York Convention, which is really important to be understood. Again, also in arbitration, brothers and sisters, we have two main different kind of arbitration. We have the ad hoc arbitration and we have the institutional arbitration. What is institutional arbitration? Institutional arbitration mainly, without going to read, it's mainly two main things, and which is huge, and I will come to that again in the third part of the presentation. Mainly, you will have institution, have a sophisticated world-class rules, and these rules, it's like a guide for all the related parties, the arbitral tribunal, the parties, any witnesses, and also the institutes is managing the all of these, but based on these rules. So it will make the life of the parties easier because they already agreed on specific rules, so they will not have more dispute about how they settle their dispute. So first of all, an institution managing the dispute through specialized rules, and also if you have a world-class center, you will have trained, educated case management team to help the party. They are not secretaries. Usually, in a lot of places, and you have in the tribunal usually assign a secretary, but the case management or the case counsel, what it's called, they are different people. They are people to support and to manage, to help the arbitral tribunal and the parties to manage the case from the start to the end. I went through that very quickly. One of the benefits of the institutional arbitration, arbitration in general, institutional arbitration in particular, neutrality, for example, about helping the parties and the tribunal about the disclosures, code of ethics, the appointment of arbitrators. I don't want to spend more time because I think we have a lot of things, but let me very quickly just to show you the difference between ad hoc and institutional, how to assign, how to appoint arbitrator. In ad hoc, you have to negotiate, you have to choose, and then to negotiate with the arbitrator about the fees and all of these stuff. But in institutional arbitration, if the parties, they don't agree about X or Y as an arbitrator, the institute will help them by, first of all, will give them suggested names related to their dispute. For example, if the dispute related to Islamic banking, the institute usually will provide the parties names, they have experience and knowledge related to Islamic banking. So they can choose from that list. If the parties still, they are not able to reach a conclusion or an agreement, here the institute will come and will assign through something called strike a rank, which is simply as the following. I will give 10 names, the same list, 10 names for both parties, and I will ask each party to strike 3 or 4 names, both parties, and then to reorder the names based on what they want. So then I will collect the 2 lists. I will take out all the strike name from both parties, and then I will take the names as per the order by both parties to give points as per both parties. Then I will take the points from both parties, then I will reorder the names, and then I will choose the arbitrators or as per the parties' preference. In addition to that, administering the financial matter, which is really important aspect in this regard. Number 2 is avoiding court. Avoiding spending time and effort by appointing arbitrator. In ad hoc, if they don't agree about the arbitrator, they have to go to the court to appoint the arbitrator. Removal and reconfirmation of the arbitrators. If there is any a challenge about the neutrality, or if there is any challenge related to that, so the institute, based on its rules, can remove or dismiss or the arbitrator, which is important. In the ad hoc, they have to go back to the court. The award scrutiny, a lot of institutions all around the world, like SCCA, ICC, a lot of institutions, they review the award before it's final, just to be sure there is no issues, there is no mistakes, and then if there is some of these mistakes may lead the award to be challenged in the court. And also another thing, you can predict the cost in ad hoc arbitration. You cannot predict the cost of the arbitration, but in an institutional arbitration, like for example in CCA or the other world-class institutions, you can go to their website to see the fee schedule for the institution, also for the arbitrator, 1 or 3 expedited or regular arbitration, as I'm trying, inshallah, if the time would allow me to go quickly through that. Quality of the outcome based on all of that things, and also facilities, providing the parties with the place, help them to reach a confidentiality instead of going to for example, hotels, or to conduct, the hearings, to go to the center, which help them to maintain their confidentiality. Also, if they need interpretation, hearing, breakout rooms, all of that things is really important. Finally, I don't want to spend more time here. I'm trying to compare institutional arbitration and ad hoc. And if you can see, based on the things that I mentioned just now, you can see more than 9 things that you are comparing institutional to ad hoc, which is institutional arbitration is more appropriate, especially for big cases, sophisticated cases, even small cases, as I will mention in few minutes. Then let me go quickly to the second subject, why ADR in Islamic finance. Now, we understand how important ADR and why we choose ADR in the commercial contracts, generally speaking, but why, especially for Islamic finance? All the things that I mentioned is really important for Islamic finance and conventional banking, for oil and gas, for communication, IT, all of these disputes. All of these things is really important for all of these, activities. But my question, is there something will make us in Islamic finance choose ADR? In addition to what I have mentioned, I say, yes, by all means, brothers and sisters. The cornerstone in our industry is the compliance with Sharia. So we have to protect our products, our contracts from breaching Sharia. And as we know, the settling the dispute here is the most critical time that we will see the result of complying with Sharia. If you ask me, Hamid, where is the most obvious time to see the difference between Sharia compliant and non-Sharia compliant? I can say during the dispute time, because here the parties, they are in dispute. So we would like to know exactly, is there an interest or no? Are they going to pay interest or no? So one of the things is really crucial and important for our industry is to settle our dispute without breaching Sharia. So because of that, let me go very quickly about a really important report has been issued by ICC, which one of the institutional centers in Paris. They issued this report. By the way, this is the cover page of the report, and they have in this report they have chapter about Islamic finance. Honestly speaking, brothers and sisters, I don't want to spend time because the time is running very fast. I will try to go to the conclusion. Let me have some quotes from that report. They say the potential of, and by the way, ICC is not a Sharia compliant center. They are not related to Islamic finance. They are not specialized in that, but they, as an expert, independent expert, they issued a chapter about Islamic finance and see the conclusion they came out with. They say the potential of international arbitration in the context of Islamic finance transactions and dealings remains completely untapped, and which is very harming to me. Also, although the Islamic financing institutions are committed to the decisions of their Sharia committee, Sharia board, whatever, the challenge that occur in the dispute can be embodied through the 2 particular examples, litigation and arbitration, both in UK. Now, brother and sister, to illustrate the importance, the high importance of ADR in our contract in Islamic banking and finance, I will illustrate that. I will summarize that with 2 real examples. Has been mentioned by ICC by names. I don't want to mention names because there is no use. You can find the names in the report, and I know as soon as I will give the example, some of you will know which case I'm mentioning. Please, just focus with me in this. We have 2 contracts, both in Islamic finance. Both the applicable law is the English law, And both contracts, they mention English law not to contradict with Sharia. Great. Both contracts, the applicable law is English law, not to contradict with Sharia. Great. The first contract, also both contracts in UK, both contract in London. Great. The only difference, the first contract is litigation in the London courts, and the second contract is arbitration, also in London. Great. So the only difference between these two contracts is the way of settling dispute. The first one is litigation. The second one is arbitration. See, the first one was Murabaha financing agreement. The English court was called. I don't want to spend more time. The result of the first one, the English judge, he refused to comply with Sharia, and he made a judgment with interest, and he said the Sharia here is not part of the applicable law, and the only law that I have to comply with is the English law. Great. So the second case was an arbitration, and it was istisna financing arrangement, but the different it was arbitration. See, istisna financing agreement, arbitration was the chosen dispute resolution mechanism. The place of arbitration was London, and the applicable substantive law was stated as follows: this dispute shall be governed by the law of English, expect the extra to make conflict with Islamic Sharia, which shall prevail. Great, which is almost the same, exact same words, almost the same words in both contracts. But what was the end of that? The arbitral award, which was enforced in England, gave effect to the party's choice of English law subject to its compatibility with Sharia. The arbitrator, who was an expert in Islamic law, issued a monetary award of both principal and profit. But this allowed claims for additional damages because although such claims were compliant with English law, they would have been in conflict with Sharia principles. So, and even after that award has been challenged in the English court, the English judge, he didn't accept that challenge, and he said this is the party's choice. So, what I would like to reach out of that, brothers and sisters, the ADR is really important for Islamic finance to protect our contract from breaching Sharia during the dispute time, regardless of the code that we are choosing, regardless of the seat that we are going to choose, regardless of the applicable law that we are going to choose. And before I conclude this part, even if you have Sharia compliant court like in Saudi, for example, as we understand, we have some different opinions in different ways. For example, in Ijara Muntaha bit-Tamlik, in Murabaha, we have different opinions. In late payment charge, Sharia late payment charge, we have different opinions. So assume your bank, your Sharia board, they choose option 1 or option 2 or option 3. All of it Sharia compliant, but they choose this opinion in Sharia. You are not sure if this dispute will go to the Sharia compliant court. They will accept that opinion. They will be in agreement with that option or no. They will approve Sharia late payment charge or no. They will approve like al-wa'd al-mulzim or no. They will classify Sharia Ijara Muntaha bit-Tamlik as leasing or no. So even if you choose a Sharia compliant court, you need an ADR. So this is the first point I think this is the most important message I have in my presentation. Brothers and sisters, ADR is a must in our contract, and it's really important to be sure there is no more disputes during settling our disputes. The second message or the third topic that I would like to mention, and now we understand what is ADR. We understand the importance and the benefits of ADR for any contracts, especially commercial contracts, including Islamic banking and finance. And then the second part is more important for us in Islamic finance, and it's not for commercial purpose, but also to be sure that we are complying with the Sharia, that we are classifying ourselves as Sharia compliant industry. The third topic I would like to discuss with you, brothers and sisters, which is really, really important, how to illustrate that how to execute that. Now we are convinced ADR important, and more important for us, let us do that in our contract. How can we do that? I think some of you expert in law, some of you are studying law, some of you know, but I'm trying to present that in the easiest way so we can understand. I know this is not by the end of the day, we have a dedicated, specialized presentation about dispute clause drafting. And my colleagues, they are conducting that, and we can happily, inshallah, if you want, we can have a dedicated workshop about a drafting ADR clause. But what I would like to mention, just to give you some important information related to this, how to understand that clause is really, really important clause. By the way, the dispute clause, sometimes called the midnight clause. Why? Because usually the parties in the commercial contracts, usually they are busy by negotiating the price, the delivery, how many days, how much discount you'll give me, when you'll deliver it, all of these things. They are gonna fight about all of these things they thought is the most important part of their commercial contract. But they forget there is small clause usually by the end of the contract called the applicable law and dispute resolution. And because of that, they call it midnight. Tomorrow they are going to sign the contract. Oh, the lawyer or the in-house lawyer or their outside lawyer, they remember, oh, we have to finalize that clause. So usually they don't put that much of attention and thinking about this. And brothers and sisters, this clause is very, very, very important. Again, in this clause, we have to think and we have to be careful about four things. And we have to differentiate between these four things. First of all, the governing law. And I will speak about it now. Then the procedural law, SEED, sometimes called SEED. The third one, specialized institution. And fourth, the place of hearings. Maybe I know, first of all, the first time I heard that, I thought, what is the difference between SEED and place of hearing? I will come to that now. Let me go step by step. Let me first of all mention what is this, these four things, and very quickly, and then I will give more details about it, and then I will go to the fourth part, inshallah. Within. By the way, organizer, when do you want me to stop? How many time left for me?
Yeah, I think you have more than 40 minutes more. 40 minutes.
طيب, لا, alhamdulillah. طيب. Brothers and sisters, the governing law is different than the procedural law. Let me talk about now we have arbitration. Let me now assume that we choose institutional arbitration. Great. So we have two main laws in our contract, in our clause. The first one is governing law, applicable law, substantive law. All of these is the same. Governing law, substantive law, and applicable law, which is the law that we are gonna the law is governing our contracts. It will be based on this law, like we saw in the example that we mentioned just now, is the English law, for example. So this is number one, and I think this is the most critical part of our discussion today. Number two is the procedural law. What I mean by procedural law, I mean we choose arbitration. So we would like to know, how is that arbitration gonna managed? We know we have the third one is institutional rules, but for example, in any country, you have what is called arbitration law or arbitration code or arbitration regulation. And we have globally unicitral model law. So this law is, the role of this procedural law is not to say the leasing should be this way or that way, or we are gonna say, for example, the price should be paid in this way or that way, because that the role is governing law, applicable law. The procedural law role is to let us know how is the arbitration gonna be managed. For example, if the parties in ad hoc arbitration, they don't agree about an arbitration, who will help them to appoint their arbitrator? This is the role of the procedural law. For example, if they mention the seat or the procedural law is the Malaysian law, is the Saudi law, the English Arbitration Act, so we will know, or they choose the international one, the unilateral model law, they will know in that situation which court, the appointing authority, which is called appointing authority, which authority will help them to appoint their arbitrators. So again, and based on that, and also if they need any intermediate, so to which court, if they don't have an institution, to which court they have to go. So the procedural law will help them to know to which court, to which judge they have to go. So if they have all of these things to help the arbitration to be managed, they have to, for example, if they would like to challenge the award, is it appealable or no? If there is a challenge, what is the ways or the things that could be, the award could be challenged based on? All of that things will, and also sometimes to enforce the award, which court will help you to reach that. So all of that aspects, it will be managed, or it will be under the procedural law. So it's really about, and sometimes they go say seat. That doesn't mean if you say the seat of this arbitration, if there is any dispute, the seat will be, for example, Kuala Lumpur or Riyadh or London or. That doesn't mean the hearings should be conducting in Malaysia, in Kuala Lumpur, in Riyadh, in Dammam, in whatever. No, that doesn't mean. And this is the fourth one, the place of hearing. Sometimes they specify in the contract, and all the hearings will be held in London. And now we have virtual hearings, and the majority of the hearings now is virtual. So all in all, the seat is different than the place of hearing. The seat is a legal term, means the procedural law, as I mentioned now. The third one is specialized institution, and I will speak about it just now. Let me go by one. Let me start with the most critical part of this, which is the governing law, the substantive law, the applicable law. Brothers and sisters, to be able to comply with Sharia or no is a result of your choice in the applicable law. Be careful about the applicable law. The procedural law is important, but from complying with Sharia point of view is not that critical, is not that important. You can choose any seat, because the procedural law, as you can say, procedure, usually how to appoint an arbitrator, how to have a court support, interim measures. So usually there is no things contradict with Sharia. So there is no sensitivity. That sensitivity in choosing the procedural law, the sensitivity is in the governing law, because your contract will be managed and the dispute will be managed based on the applicable law that you are choosing. Again, fortunately or unfortunately, sometimes in our products, especially the cross-border products, usually in Islamic finance and banking and finance, we are choosing English law. I'm just saying what is there. I'm not happy with that result, but I say what is there. So sometimes, as we saw in the two exams, the real examples, and I know some of you, if you are related to this, you know a lot of examples. Just saying English law not to contradict with Sharia, it's not enough. And sometimes the other party, they will not agree on that because of which Sharia you are talking about. Are you talking about Shafi'i madhab or Hanbali madhab or Hanafi madhab? In addition to that, even not only madhab, sometimes is al-wa'd mulzim or no? What about al-wa'd? What are you doing about late payment charge for charity? All of these things, even if you are choosing Hanbali or Hanafi or Maliki or Shafi'i, you would not be able to know. So they would like to know something tangible. They would like to see like law, is Sharia law, just to be able to see it and just to review it. So again, brothers and sisters, if you can choose Sharia compliant law, which is great. If no, not less than saying not to contradict with Sharia. And this is not enough. Because you have to know which Sharia. So not because I used to work in Ayufi, but I think is the most preferable way to define Sharia is to say as per Ayufi Sharia standard. This standard is global. This standard is not one madhab or two madhab. This standard is, you can find in these standards all the things or the majority of the things that you are looking for, even if it's not clear in the madahib, such as call whatever you want, something related to credit cards, a lot of things. So again, brothers and sisters, if you would like to choose any applicable law, choose it, but not less than having three things here. Choose the applicable law, then say not to contradict with Sharia in any language that you want, and define Sharia. Define Sharia, and I think the most appropriate way to define Sharia is by saying as per Ayufi Sharia standard. So this is, brother and sister, it's the most critical and important thing. And the second message, from all of this presentation, I would like to highlight these two messages. The second message, and maybe it's more important than the first message, is be careful and choose the applicable law and make it in comply with Sharia. And the third, the most important message is, it's not enough to choose applicable law, not to contradict Sharia in as per Ayufi Sharia standard. It's important to choose arbitration and or mediation. As we saw, if it's go to litigation, some of the courts all around the world will not comply with that. If you choose arbitration, usually the court globally will apply with that or will comply with that, because arbitration is more parties' choice. The courts usually will respect the parties' choice more in arbitration and mediation, not because of Sharia, because of the law. They respect the parties' choice in arbitration. So brothers and sisters, again, choose the applicable law, make it conditioned by not to contradict with Sharia, define Sharia with Ayufi standard, and number 4 is choose arbitration and or mediation to be sure the applicable law that you choose is in the court tomorrow will be respected. So this is the first one. The second one, the procedural law, I think this is not that big issue. Choose any procedural law, and which procedural law you have to choose. Usually see the activities or where is usually the arbitration will be conducted, and from where you need a support from the courts. And also one of the things, usually the parties will choose the procedural law based on, some countries they has been called as ADR friendly countries. Their judicial system is supporting ADR. They don't accept the challenge. They don't go to the substance of the award. So you have to choose the procedural law in the countries. They are ADR friendly countries. But from Sharia point of view, in my opinion, in my humble opinion, I don't think it's that sophisticated, that difficult. So you can choose any applicable law. And here the choice also it's critical, but not from Sharia point of view. From technical point of view, you have to choose the procedural law that you will not be suffering with. Number 3, institutional arbitration, institutional rules. Brother and sister, I mentioned that the applicable law role, the procedural law role, and if we would like to go with institutional arbitration, we have to choose institution and why. I mentioned why institutional arbitration is really, really important for us. And what is the added value of the institutional arbitration? But now we have procedural law, the rules. What is the, and if we have procedural law, what will be the role of the institutional rules? Usually, the procedural, institutional rules will give more details. Usually, the laws, as any law all around the world, it will be more generic. But the procedural law, the institutional rules, will give you more details and helping you more in settling your dispute. Number 2, why? Let me say it in another word. How and why I choose institution A or B or C or D. And here also there is involvement related to Islamic finance for the 4 things. First of all, the institution will give you rules, and you have to be careful to choose a center. They have world-class rules with the best practices to help you to reach the efficiency in settling your dispute. For example, if you have sophisticated rules, it will help you in appointing your arbitrators efficiently, how to choose the arbitrator, to dismiss the arbitrator, and also to help you if, for example, there is no cooperation from the other party, how the institution, how the center will help you to proceed with your case. All of these things is very critical for you in managing your disputes. So the first one, for its rules. Number two, for its roster. And there is an involved for Islamic finance here. The roster, sometimes the parties, they need only help by nominating an arbitrator, and sometimes they don't reach any conclusion, an agreement, so they need help from the institution to appoint the arbitrator. If you choose an institution, they don't have a roster, a part of their roster, specialized arbitrators in Islamic banking and finance. And as you understand, sometimes it's not enough to have someone understand Islamic finance and Islamic banking and finance. You need someone to understand the treasury product in Islamic finance. You need someone to understand deeply the M&A, merger and acquisition in Islamic finance. You need someone to understand deeply private equity, venture capital. You need someone to understand all of these products. So it's not enough to reach the efficiency to have someone understand all Islamic bank and finance, or to have someone expert in M&A, but he or she doesn't understand Islamic. So one of the things, you will choose your center based on the institution, based on their roster. Number three is the case management team, brother and sister. The sophisticated center, they have another team, as I mentioned in the beginning. Their role is to help the arbitral tribunal, the arbitrator, the parties, to help them in managing their case. So you have to have sophisticated, well-educated, specialized case counsels or team to help you in managing your dispute in the right way. Right. So the fourth angle is the place of hearing. Don't forget, now we have virtual hearing. So you can, and even it's not that important to mention in the contract where is the hearing will be conducted or they will be held. So you can choose that later, and the institution will help you in reaching that or in choosing that. So let me finally just illustrate that this one of the, you can say, model clauses. And brother and sister would like to focus with me about the four things that we mentioned: applicable law, or the substantive law, procedural law, and also the procedural rules or the institution. And number four is the place of hearing. And let us see how is this model clause help us in that. Let us read that together. Please focus with me. Any dispute, controversy, or claim arising out of relating to this agreement, including any sale transaction, shall be settled by arbitration, administered by Saudi Center for Commercial Arbitration, SCCA, in accordance with its arbitration rules. The governing law of the agreement shall be English law to the extent such law don't contradict Sharia as enacted in the Sharia Standard of Accounting and Auditing Organization for Islamic Financial Institution, AYUFI, of Bahrain, in which case Sharia shall prevail. The seat of arbitration shall be Kuala Lumpur, Malaysia, and all hearings shall be held in London, United Kingdom. Great. I need all of you now, just very quickly, try now by your eyes, even by your eyes, to say where is the four components. Where is the applicable law? And don't forget, we have in applicable law, we have to define the applicable law, then to make it condition not to contradict with Sharia, and to define Sharia by AYUFI. All of that in the first component, applicable law. Then where is the procedural law? And then if I have time, I will ask some of you where is these four things, but because of the time, I will say it now, but try now to examine yourself. And the third one, where is the rules and institutional rules, and then where is the place of hearings? Great. Are you ready? طيب. See now, the governing law, the red part of the clause is the governing law, the substantive law, which is the governing law of the agreement shall be English law to the extent, and don't forget, now we said that we have to make that condition not to contradict Sharia and to define Sharia with AYUFI. So the red part of the clause now is the governing law with the three components that we discussed earlier. Great, brother and sister. Okay, shall we move? طيب. I will go now to the second part. The
Yes.
procedural law. See, the procedural law, the green part, the seat of arbitration shall be Kuala Lumpur, Malaysia. And again, this doesn't mean the hearing should be in Putrajaya or here or there. No, 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 no. Sorry, I'm trying to remember the place I went to in Malaysia. So that doesn't mean you have to hold it here or there. That means which court will help you, under which court, which arbitration law the arbitration will be managed. Great, brother and sister, great. Shall we go to the third part? Ready?
Yes.
Institutional rules. Specialized institution. So here we see the red bar, the blue bar. Here, administered by the Saudi Center for Commercial Arbitration in accordance with its arbitration rules. Great. The fourth part, and again, it's not a condition. It's not important for any contract to mention the place of hearing. It's not a condition. The three component is really important. But the fourth one is you can mention and you cannot to mention it. But just for educational purpose, I try to make it part of the clause, and it's not wrong. Just to let you know the difference between place of hearings and the seat. So and all see the light blue place of hearing. All hearings shall be held in London, United Kingdom. Great. Brother and sister, we are done with the most critical and important part of my presentation. In the coming 10 minutes, I will just try to go very quickly with you to give you a background about some of the newest, or you can say some of the sophisticated product and services some of the sophisticated world-class center are providing, such as SCCA. And I would like to give you just very, very quick background about SCCA. First of all, SCCA, the Saudi Center for Commercial Arbitration, has been established by cabinet decree in Saudi in 2014 as the first institutional arbitration center. Again, SCCA is non-for-profit organization, is not part of the government. We are not governmental entity. We are not a private sector. We are independent from the government and from the private sector. We are international. We are providing our services for any parties all around the world. It's not a condition to have any party Saudi. The Saudi is just a name where the center has been started. As I mentioned, this is very conservative industry. So we started in cooperation with one of the oldest, most respectable center globally, which is the American Arbitration Association. It's international, the International Center for Dispute Resolution. Our rules, our team has been trained in New York. And then we have the readiness of SCCA started from the legislative law, which is the procedural law, the Saudi law, and also this is our rules. And by the way, you can download our rules in Arabic and English from our website free of charge. And also in addition to that, you will have very valuable documents will help you if you would like to understand more about this industry. So for example, a guide to, we have very, very important, by the way, guys, we have very important book called A Guide to draft. What I mentioned now is you can find a lot of it in the guide that we have, a guide to draft your dispute clause, and also a code of conduct. You will have very valuable documents. We are managing the cases based on these documents. We have now, alhamdulillah, an office in Riyadh, and now in Sharqiya, the Eastern Province, and also in Jeddah, and also in King Abdullah Economic City. And we have all the facilities like translation, live translation, video conferencing, all of these facilities. We have very effective relationships such as international law firms, company, corporations, international universities, such as the great and respected relations that we have with IIOM. And also we are representing Saudi globally. So we are representing Saudi in the UN, and also we have effective relationship with different organizations and law firms globally. Alhamdulillah, arbitration centers usually takes from 5 to 8 years to register the first case. Within only 4 years since we opened in October 2016, alhamdulillah, we have all of these industry. 55 of our cases is construction, and the second biggest part is banking and finance and capital market, in addition to education, engineering, energy, oil and gas, etc., etc. And by the way, the parties of the dispute in the past 4 years from all of these 12 countries and we hope that we see more countries. We hope not to see more disputes, but we hope to see more countries if there is a dispute from Islamic courts. Our roster, as I mentioned, from 2420, we have 2420 arbitrators and mediators, male and female, from 25 countries all around the world. Now they are speaking in 19 languages from 20 fields. And as you can say, Islamic banking and finance is really important part of that roster. So also to make our center is global and to keep the compliance with the international best practices, in October 2019 we launched the International Advisory Board to help us to comply with that. There are 14 experts from 11 countries, and also we also launched a committee called Committee for Administrative Decisions to help the parties to, before we have an arbitral tribunal, to help them to settle their decisions related to arbitrated challenges, the dispute concerning the base of arbitration, concerning the number of arbitrators. Let me go very quickly, brothers and sisters. If you would like to be a successful center, you have to take care not only about giant cross-border companies. It's really important. And we have the arbitration, the regular arbitration or ordinary arbitration. Also, we take care, and some other world-class center, we have to take care about SMEs, small and medium enterprises, entrepreneurs. Also, we have to take care about the different things. Let me take you very quickly through it in the remaining 7 minutes. I think, Prof, I have 7 minutes. Am I right?
Yes, correct.
Great. Right. Let me start with the arbitration. Under arbitration, we have 3 different services or product in arbitration. We have the ordinary arbitration, we have what is called expedited procedures, and we have the online dispute resolution protocol and platform. What is the difference between this? You can differentiate between these products based on the size of the companies. Usually, it's not a condition, but usually this product is meant to serve these different, size of the corporations. The regular arbitration is for the cases 4 million and above, and usually it's for big companies, and some small companies, medium companies, they are using ordinary arbitration. But sometimes, if you would like more cheaper, faster arbitration, you will choose expedited procedure, which is meant to serve the cases less than 4 million. It's cheaper by 30%, and the procedure is less by 30% comparing to the ordinary arbitration. We have specialized rules, appendix to our rules to manage what is expedited procedure. And by the way, by default, if you choose SCCA, if there is a dispute, if the case value 4 million or less, it will be directly it will be managed under expedited procedure. And the good thing, we have something called opt-in and opt-out. Even if the dispute lists 4 million and less, if the parties, they decided to go to ordinary arbitration by the agreement of both parties, they can opt out. And even if the dispute 40 million, 4 billion, if they choose to opt in to go to expedited procedure, they can go to opt in to expedited procedure by the agreement of both parties. The ODR protocol is meant to help the macro and micro businesses, entrepreneur. So it's meant to settle the dispute of the value of 200,000 riyal and less. So, and it's not by default, the part they have to choose, or they mentioned in the contracts, if there is a dispute less than 200,000 riyal, they have to settle that through ODR. By the way, brothers and sisters, this ODR is virtual 100% from applying your case through the hearings, and usually they can manage the case without hearing, and if there is a need, it will be video conferencing or conference call, and then the award will be issued through the system. And even if there is a witnesses, everything will be managed virtually 100% to help the, and also the cost there is huge difference in the cost of the ODR and the time compared to the ordinary arbitration. I know there's a lot of details. I know the time will not help me to go through that, related to some highlights related to our rules, and then about the expedited, but I mentioned the most important elements related to expedited arbitration. And then this is the ODR. What is the threshold of the ODR, and what is the nature of ADR, and how and who should benefit from the ODR. The fourth one, yes, I would like just to mention the value of the cases that I mentioned. All of it's in real. Sorry, I didn't calculate that in different currencies, but it's in real with the US dollar 3.75. All in all, the fourth product in arbitration I would like to mention, I mentioned the ordinary arbitration, the expedited, and also the ODR. The fourth one called emergency arbitration. Simply, this product is, as per our rules, we can assign an arbitrator within 24 hours, and the procedure order will be issued in 3 days, and the award should be issued in 14 days, not more than 14 days. What is the idea, very quickly, of the emergency arbitration? Sometimes there is a dispute about, assets, and you don't want that, the dispute asset to be changed until you assign an arbitrator or tribunal, and until the issuance of the award. It will take time, and it might change the asset of the dispute. So you need an emergency arbitrator to issue interim measure. So just to hold, for example, like an asset, or to freeze an account, or freeze a check, or all of these things until the arbitral tribunal, and it will be a temporary award, and it will be forced. And part of the reason how to choose and why to choose the procedural law, one of the things they have to take care of, if there is a sophisticated country, their arbitration law, it will give support and efficiency to apply or to enforce the arbitral emergency award, or sometimes the interim measures. So it will be enforced by the related court in this country or that country. So we provide this service. And second, the mediation, and we have in mediation two main products. We have the mediation, as I mentioned in the beginning. We have specialized dedicated rules for mediation. We have specialized dedicated roster for mediators, men and female, and also we have a specialized team for mediation. Finally, during the pandemic, we found there is a need to come up with a special product to deal with the pandemic. So we launched something called a COVID-19 Emergency Mediation Program, EMP. This product, the difference between this and the regular and ordinary mediation is 4 things, very quick. First of all, this product, it will be conducted, or it will be managed 100% virtually. No need to choose to the parties or the mediators to choose to meet the party. So it will be managed 100% virtual. And as you know, this is really important during the pandemic, the lockdown and the things that you know. Number 2 is we made the fees is cheaper by up to 67% comparing to regular mediation. Number 3, it's and this is really important, brothers and sisters, in cooperation with the Ministry of Justice in Saudi Arabia, we reach an agreement. Any settlement will come out of the mediation. We provide the parties with additional service, that we can convert this settlement into enforcement bond. And I know the lawyers here among you, they understand very well what does enforcement bond mean. That it will be dealt with, this settlement will be dealt with as any judgment from the court, final judgment from the court, will give it more teeth, more power in the enforcement if you give it, the enforcement bond classification. So these benefits is, you can say, the difference to help the parties to reach settlement during the COVID, and we extended that product until the end of April. So until now, we are providing the EMP for the parties if they agree on that. Finally, we have also limited service suits. For example, we are helping the ad hoc cases and industry by 3 main services. First of all, we launched something called the SSA selection and appointment services. Even if you are ad hoc, and some courts even, they are reaching us to help them, because we have very sophisticated roster. For example, if you have an Islamic banking and finance case in banking or capital market, even if it's ad hoc, now the contract already there, and you cannot change it to be under SCCA, it's ad hoc, but you need our help to nominate an arbitrator, specialized arbitrator or mediator, understand in Islamic finance, in M&A, in treasury, in etc., etc. What is the language that you need? What is the law that you need this arbitrator or that arbitrator specialized in? Give us your conditions, and we are able to help you by providing you with names meeting your requirement in all of these things and any other things that you are thinking of. Even if we are not managing the case, we can help you, and we are helping you to give you arbitrators in different way. We have three kind of products. I don't have time to say the differences between it, but you have sufficient information about all of these products: appointment only, nominating only, or nominating and appointment services. And finally, and also we have another services called under the a la carte services, or limited services suits. But this is very quickly the presentation that I'm tried my ultimate best to cover a lot of information. Sorry, I spoke very quickly as usual, but please, I will discuss with you now if you have any question or any things that you would like to mention. Thank you again, and I would like it's brother Saad. The floor is yours. Thank you.
Yeah, thank you very much indeed with this very insight presentation from Dr. Hamid Merah. Inshallah, we will open for the Q&A, and before that, I would like to let you know that in our presence today, we do have the presence of our Dean, Professor Dr. Selina Qasim, and also Professor Dr. Unku Rabia. I think he's one of the professors that you know. And also in our presence today, we have Professor Dr. Rusni Hassan, and also the former Dean, IIBF, Associate Professor Dr. Said Musa Al-Habshi, and many and almost all of our staff here in IIBF present. And I would like also to highlight that in IIBF, we do have various programs. We have PhD in Islamic Banking and Finance. We also have Masters in Islamic Banking, Master of Science in Islamic Banking and Finance, which we actually offer our programs in both English and Arabic languages. And we do have some students from Saudi Arabia as well. Okay, before we go to the questions and answers, I also would like to highlight a few things that Dr. Hamid Merah has actually highlighted. Firstly, at the first, he actually discussed the ad hoc and the alternative, the dispute resolution, that's the ADR, ad hoc ADR, and also the institutional ADR. And also he discusses the choice of law clause or the governing law, and also the procedural law, and also the procedural rules, also the procedural rules, and also the place of hearing. There are so many issues. I got some answers here actually in these very noble discussions. If we look at back in the history in 1963, we can see some problems with the choice of law clauses, especially in Saudi government and American company or Aramco company at that time in 1963. There was a dispute where the Sharia law was actually the prevailing law or the choice at that clause, as a clause of choice, as a law of choice. But the problem was the arbitrators were able to reject the Sharia law, which is based on the Hanbali school of law. But today we can get the answer here where we can simply define the Sharia law because the question that time was, what sort of law is this law is under a special or standard that we can adopt as a law? So that was the question that the arbitrators who are actually from the Saudi side cannot be able to answer. So that's why the arbitration was not choosing the Sharia as the chosen law. At this time, we have the answer from Dr. Hamid Merah that we can define the Sharia laws with the IOF standards, or with, I think maybe in the Malaysian case, we do also have the Bank Negara standards, for instance. So all this could be, I think, one of the areas that could really improve the arbitration or the ADR in Islamic banking and finance. Thank you so much for highlighting all this. And I believe there are a lot of questions that the audience can ask, and we can open the floor. If anyone wants to ask a question, please, you can directly unmute yourself and start asking.
Assalamualaikum warahmatullah. My name is Abdurrahman. I have one question only. Based on your experience, Doctor, are there any dispute arise due to the misleading information in the financial statement of the Islamic Bank?
Can you clarify more your question, please?
My question is, based on your experience, is there any dispute arise due to the misleading information? Because we know that there is different standard of accounting. Okay, there is IFRS, there is IOF, and so on. So, is there any dispute among the parties, among maybe the stakeholder or the users of the financial statement? I mean that the dispute come from that information. Thank you very much, Doctor.
Thank you, brother. As per my knowledge, I haven't seen that such a dispute arises from the you can say the accounting part of the contract. But usually, during the disputes, sometimes the arbitrators or even the judge, they need to see some financial information. But as per my knowledge and experience, I haven't seen a dispute arise from that. If you allow me also, brother Saad, I saw here in the chat some question. If you allow me just to answer some of these questions.
Yes.
And before I forget, I would like to welcome all of these, respected professors and close friends, and I'm honored, wallahi, to have them in this presentation. Also, I saw a very close name to my heart, brother Khairul Nizam. He is leading one of the industries, and close friends. So I'm really happy to see him from Malaysia. So I saw your name, and one of the things made me, enthusiastic when I started my presentation to see that good name, and also all of the professors that you mentioned their name. I'm honored to see all of them again, and I hope, inshallah, soon that the pandemic will be disappeared, and inshallah, bi'idhnillah azza, will shake hand again, bi'idhnillah azza wa jal, in Kuala Lumpur and in Riyadh, bi'idhnillah azza, all of you, bi'idhnillah azza. Going very quickly to the questions that here he said, I don't know, he or she, I don't remember. All in all, is KSA arbitration law is based on honest trial? Yes. So the Saudi arbitration law is based on honest trial, and it's recognized in the honest trial website. So this is one of the things. Someone asked me about the committee in SAMA. Is it reporting to Minister of Finance? No, it's independent. But I have to mention something really important related to that, because the banking dispute, usually the applicable law or the applicable court is that committee in SAMA. But even that specialized committee allows the parties to choose the arbitration. So if the parties, they mention in their contract, if there is any dispute out of this contract, it will be settled by arbitration. And if they would like to say also SCCA rules, that also will be respected and enforced in Saudi, even if we have that committee. So I think this, to the two questions, I think I saw in the chat.
Yeah. So based on your experience, are there any dispute arise due to the misleading information in the financial statement of the Islamic Bank? Are you referring to that? Based on your experience, are there any disputes arise due to the misleading information in the financial statement of the Islamic Bank?
Yeah, this is the question that our brother just mentioned, and yeah, just in short, I haven't seen that.
There is one question here also. May I know of if Saudi Arabia follows unilateral arbitration? Oh, you just answered this one.
Yeah.
Okay. Okay, any other question before we close the discussion? Maybe I will ask you one question, Doctor. What do you think the future of Islamic banking and finance when it comes to the the way, based on your experience on international disputes resolutions, because most of the time you can see the Sharia is not really favored in many cases. So what do you think is the future?
Well, brother, I think this is the main message I would like to come out of this really important webinar with. As I mentioned during the presentation, if we would like to protect our industry, in my opinion, my humble opinion, we have to make the way of settling our dispute is ADR, even if you have Sharia compliant court or no. Number one. Number two is to be respected. And also, I don't want to mention, in the ICC report, I encourage all of you to see that report, which is very valuable, especially the chapter related to Islamic finance. And it was very harming. ICC report concluded that Islamic finance institution, I don't agree with that conclusion, by the way, but they concluded, because they were amazed. They saw the majority of the contract they reviewed is not ADR, is not arbitration. So they said, they felt and they concluded that the Islamic financial, or the majority of the Islamic financial institution, they are not serious in complying with Sharia, because they would like to satisfy their Sharia boards. And they know if they don't want to comply with Sharia, again, I don't agree with that conclusion, but this is there. They just to satisfy their Sharia board, they say whatever they want in the contracts. But when they say litigation and they choose any other applicable law, by the end of the day, Sharia, it will not be enforced. So they found the institution intentionally, they are not serious in complying with Sharia, which is really hard and which is not the reality, inshallah. So because of that, brother, we have to be very careful. Lawyers in this industry, law firms, Sharia scholars, and even regulators, I think we have to protect and don't forget again, our industry now is global industry. Our industry is cross-border industry. The sukuk, not only sukuk, and just an example, it's cross-borders. So we have to protect this contract by three things very quickly. First of all, to settle the dispute through ADR, because all the court, you can say the majority of the courts globally will respect the parties' agreement. Number two is to condition the applicable law with the not to contradict with Sharia. Number three, we have to define Sharia by a UF standard or any other standard that will reach the same conclusion. I think these four keys will help us to protect Sharia. And don't forget, brothers and sisters, this very crucial and very important to the extent that International Independent Center, they felt that we are not serious to comply with Sharia.
Thank you so much for your response. I think Brother Khairul Nizam want to ask or want to share something.
Yes. Assalamu alaikum, Doctor. Thank you so much, Doctor, for the presentation. Doctor, you mentioned in one of the slides, sorry, I know we're talking about Islamic finance here, but you mentioned in one of your slides that 1% of the cases that you have dealt with was on education. As I said, I know this on education. Dr. Hamid?
Yes, you mean one of the cases related to education?
Yes, I saw on the charts that
yes.
One of the areas is on education.
Great.
Could you let us know a bit more on that? I'm sure the professors and the lecturers here and me personally would really benefit from that.
Sure.
What sort of dispute on education here?
Great, brother Khairul and brother and sister. That chart showed the cases that we registered in SCCA in the past 4 years. So these are the industries that we have, and 1% of the cases that we received in SCCA in the past four years from the education sector. And as you know, brother Khairul and everyone, based on that, number one in arbitration and mediation ADR is confidentiality. So based on that, we.
But in general, perhaps.
Yeah. So sometimes the business. For example, sometimes you find a dispute between contractor is building, so you can classify that. I'm just thinking loudly about, how can we have a dispute in education system? Sometimes even contract, for example, to develop curriculum for program, something, contractor is developing program for institution or university or even a ministry to develop curriculum, to develop program. It's not always, construction about, physical things, but some of the dispute will arise out of the education system. And by the way, you asked about the education. I think, and we are dealing, and we have a good relationship with IOM in that. I think educating and the students, and even not only the student, raising awareness and the capacity building for this industry is really important. And I think to be within the international best practice is more importantly to protect our industry. You have to speak the world language. You have to deal with the best practice that the world is speaking. So for example, in SCCA, we had an agreement with the Chartered Institute of Arbitrators. They are 100 years and more. So now their fellowship in arbitration is 3 modules. So even a retired judge with 30 years of experience, they study this, because as we know, there is some common grounds between judges and the courts and arbitration, but there is differences between this and that. And I met different very senior judges, not only Saudi judges and English judges. And they gave me their stories about what is the difference in their life when they were judges and now when they are well-known and good arbitrators. And they found themselves, after, for example, 30, 35 years of experience in the courts, the arbitration, institutional arbitration in our particular, is different story. There is common ground, but there is different. Because of that, you will see to the level of a well-respected 35 years experienced judge. He is attending programs to be able to absorb the best practices. What about the other lawyers? What about, academician? What about? It's really important to understand, the skills, and to get these skills in addition to the knowledge. Maybe we can find the knowledge in the universities, but, the skills, it's really important to have it from practitioners. So this is number one. And also number two, we have very good cooperation with the university. We started what is called the moot in arbitration moot. We did that within Saudi, and we found, and you can see in Arabic, in social media and Twitter, the feedback from the students, how it was game changer in their life when they started the competition, the moot. So they felt, they felt the skills needed. And also some of the universities, they assign academician to supervise the teams, or also academician in addition to practitioners, lawyers and arbitrators. So, and we found amazing result. Alhamdulillah, we started within Saudi last year, 24 teams, and this year within GCC countries, 54 teams from all GCC. Next year, inshallah, I'm sure that we will have team from IOM, and it will be international. So we will have teams from all around the world. And I'm sure, inshallah, the IOM team will be a very strong team and will compete with the other teams, inshallah. So I think to start from the universities is really important to build sophisticated industries. And by the last few seconds, brother and sister, in all aspects of our industry, it's very harming to have 2 choices, to choose Sharia compliant or good quality in banking, in finance, in IT, and it's really we are making something bad to our Sharia to make good quality or Sharia compliant. We need both at the same time, best practices, best international practices, and we need the best quality, and at the same time to be Sharia compliant. Because of that, we need our arbitrators. It's not enough to understand Sharia. It's a really important thing. But at the same time, you have to understand the best practices from these fellowships and also to practice in the best way. And we need our center. Brothers, I would like also to close this. Our centers, our ADR centers, we have it to be within the best international practice that will not harm Sharia. To be Sharia compliant doesn't mean that you have to be with the practice 50 years ago, 60 years ago. You don't update your rules, you don't update your roster, you have only mashayikh. You have to be within the best international practices. So this is the message that I wanted to share.
Thank you, Doctor, and thank you, IIUM.
Thank you very much, Doctor, for the response. Somebody sent me one question here, but in Arabic. He said, لماذا حتى الآن لم تتحد المعايير مع أن نسبة 90% منها واحدة؟
والله هذا سؤال أنا this question I will leave it. I think there is a will. يعني 4 years ago when I was in IOFI, there is a will, especially from the leading countries. In the front of these countries, Malaysia and Islamic finance, there is a will to have unified cross-border standards. I think this could be reached. We are not far from that. You can say holy goal, ذلك الهدف العظيم حقيقة. لكن I think we have to work to that, and I agree with this. We have to reach, you can say, unified standard, and that could be reached, inshallah. And by the way, I think our brothers and sisters in ISRA, they did a study about. They compared the different standard, even the Majma' al-Fiqh al-Islami, the Islamic Fiqh Academy resolutions. They did very, as per my bad memory, they did a good study about the comparison between this. And I think if you make a scientific study, what is the differences? I believe the differences would not be that big, so we can reach common and unified standards.
Sure. Okay, thank you so much. Any other question?
ممكن سؤال دكتور؟
Okay, تفضل.
صوتي مسموع؟
Yes, please mention your name, your faculty, and.
بسم الله الرحمن الرحيم، الحمد لله رب العالمين والصلاة والسلام على المبعوث رحمة للعالمين نبينا محمد وعلى آله وصحبه أجمعين. أنا سيد هاشم من مصر وطالب ماجستير في IBF. أرحب بسعادة معالي الدكتور حامد، وفرصة طيبة إن احنا شفناه، وحابب أقول أتمنى إن احنا نشوفه أكتر من كده، نشوفه بالصدفة. احنا عايزين نستفيد من علمه أكتر، اقتراح متواضع لو أمكن إنه يكون في اجتماع نصف سنوي مع كبار الأكاديميين على مستوى العالم في المصرفية الإسلامية، علشان نقدر نشوف التحديات والحلول اللي واجهوها في الوقت المعاصر الآن، علشان نستفيد من علومهم. بارك الله فيهم وشاكر جدا لحضرتك. في أمان الله.
الله يحفظك، جزاك الله خير، الله يعطيك العافية.
جزاكم الله خير. Any response to this? Oh.
I don't have a specific response, but I think I don't know to answer in Arabic or English, but because the question in Arabic جزاك الله خير، الله يعطيك الصحة والعافية. أعتقد المنصات الدولية للصناعة مثل مؤتمرات إسرا، مثل مؤتمرات أيوفي، مثل هذه المؤتمرات اللي هي الجامعة للصناعة تحقق جزء من أهداف ما ذكرت، جمع الأكاديميين وجمع الممارسين وعلماء الشريعة ذوي العلاقة والريجوليتر، الجهات الإشرافية والرقابية، تحقق أهداف شريفة حقيقة. من أعظم اجتماعات ومؤتمرات الصناعة مؤتمرات إسرا ومؤتمرات أيوفي اللي هي تجمع الصناعة، وهي على سبيل المثال للحصر. فمثل أنا مع دائما محاولة توحيد الجهود ما استطعنا، أن لا ننشئ أشياء إضافية ربما تشتت الجهود الموجودة. فتعظيم الاستفادة وتعظيم الانتفاع من هذه المنصات القائمة حاليا العظيمة في الصناعة، أتوقع تعزيزها وتعزيز أهدافها ووصولها إلى شرائح أكبر ربما يحقق كثير من هذه الأهداف.
جزاكم الله كل خير وأحسن الله إليكم. The next thing before we conclude the session, I would like to invite Brother Zul to share one of the videos for the university. Please, Brother Zul.
Selamat datang, ahlan wa sahlan. Welcome to the International Islamic University Malaysia, or IIUM, your garden of knowledge and virtue. IIUM was established on the 20th of May, 1983. The philosophy of the university was inspired by the spirit of Tawhid, leading towards the recognition of Allah as the absolute creator and master of mankind. IIUM triumphs to lead the way to become the Khalifah of Allah, to expand the culture of Iqra, to fulfill the amanah that is entrusted to us, and to realize the meaning of Rahmatan lil Alamin. IIUM has several campuses spread across several states of Malaysia, offering nearly 200 academic programs in 17 kuliahs and institutes. The main campus is in Gombak, Selangor, covering 700 acres, beautiful architecture with elegant Islamic style buildings. IIUM is blessed with majestic green forested limestone hills and a cool calming river, nature's wonders of flora and fauna, making it a conducive environment for study. KIRKHS is the largest kuliah in the university with more than 5,000 students. It was formed to integrate human sciences and reveal knowledge disciplines. The kuliah offers courses that bridge the divide between Islamic and secular sciences. Other kuliah of IIUM in Gombak campus are Kuliah of Economics and Management Sciences, Ahmad Ibrahim Kuliah of Laws, Kuliah of Engineering, Kuliah of Architecture and Environmental Design, Kuliah of Information and Communication Technology, Kuliah of Education, Center for Languages and Pre-University Academic Development or CELPAD, and IIUM Academy of Graduate and Professional Studies. The campus offers complete range of facilities, including on-campus housing, a mosque, 2 state-of-the-art sports complexes with Olympic-sized swimming pools, a fully equipped library with more than 2 million printed and digital materials supported by online databases, a medical clinic, convenience stores, a post office, and 3 Malaysian commercial banks. The Kuala Lumpur campus at Persiaran Duta houses the International Institute of Islamic Civilization and Malay World, or ISTAC. ISTAC aims to proliferate studies on Islamic civilization and Malay world through learning, research, and exchange ideas and knowledge. The Kuantan campus is located on 1,000 acres of land, just like a garden within a valley surrounded by large greenery. This campus is well equipped with state-of-the-art technology for teaching and learning that offers medical science, pharmacy, allied health sciences, nursing sciences, and dentistry courses. The IIUM Medical Center in Kuantan was built on 27.8 acres of land, equipped with 350 beds for patients and supported by more than 133 specialists. The IIUM Medical Center also includes the development of an undergraduate and postgraduate teaching hospital and tertiary level center, complementing the medical and allied health faculty provisions. Another IIUM campus, which is situated in the state of Pahang, is a center for foundation studies, which is located in Gambang. The Pago campus in Johor houses the Kuliah of Languages and Management, or KLM. The population of IIUM is about 26,000 students, 20,000 undergraduates, and 6,000 postgraduates coming from 117 countries. To date, IIUM has 91,267 alumni. IIUM will continue to be competitive in its mission to make Malaysia a global center of excellence for tertiary education. It will also continue to make significant contribution, one of it to serve the Muslim Ummah. IIUM, leading the way. Khalifah, Amanah, Iqra, Rahmatan lil Alamin.
Okay, thank you so much. I would like to lastly extend a very humble and a very important and extensive salam to you by our Dean. And she actually personally told you that she really appreciates your sharing session, and we really thank you. And all IIBF staff and students are thankful to you. We really appreciate your presence and your sharing session today. And we look forward for more collaborations and more talks and sessions like this, inshallah, in the near future with your institutions and your country as well, and other Saudi Arabian universities and institutions.
Brother Saad, I would like to thank you again for managing this webinar, and I would like to thank IOM the Institute of Islamic Banking and Finance. I would like to thank His Excellency Professor Dawood Bakr, also Excellency Prof. Qasim, and also I'd like to thank all of you one by one about your attendance, about your time, and I hope inshallah to see you بإذن الله soon بإذن الله عز وجل. جزاكم الله عنا خيرا. استودعكم الله الذي لا تضيع ودائعه. والسلام عليكم ورحمة الله وبركاته.
جزاكم الله خير. السلام عليكم ورحمة الله. Shukran. I would like to also thank our presence. Actually, we have so many audience from various countries, from Ahmad Bello University in Nigeria, from Amana Islamic Bank, Philippines, from Finance Accreditation Agency, from Hope Trust Zimbabwe, also from International Sharia Research Academy, ISRA, from Maldives, Capacity Development and Government Institutions, from Mizan, Mizan Bank, Securities Commission, Malaysia, also from Somali National Bank, from the University of Sultan Zainal Abidin, UNIZA, also from UKM, University Kebansa and Malaysia, also from the University Technology Merah, also from University of Dhaka, Bangladesh, also from the University of New Orleans. Thank you, everyone, and wassalatu wassalamu ala rasulina Muhammad. I would like to stop here, and wabillahi tawfiq wal hidayah. Wa see you again. Wassalamu alaikum wa rahmatullahi wa barakatuh.
Thank you, Dr. Merah. See you soon.
Thank you, brother. Thank you.